Well, yeah, thanks very much. And this is another one of WSC Group's webinars designed to try to educate our clients and others on some really important issues that they might need to attend to. And today we've got James Wiley, who's Special Counsel for Hall&Wilcox, who are a law firm based in Sydney. And it's really interesting. I heard James speak on this very issue only a few weeks ago, and asked him to come and actually just speak on certainly the area of the UK inheritance tax and some of the things that our clients might need to be aware of. So I'm just going to hand it over to yourself, James. Thank you very much for coming and doing this presentation. I believe the presentation will probably go for about half an hour.
Yeah.
And we may have time for questions after that. So I'll hand it over to you, James.
Thank you, David, and thank you for everyone who is able to attend. As you may be able to tell from my background, I'm originally from the UK, and I practiced law there for 6 years before moving to Australia 4 years ago. And part of the planning there is very much driven around inheritance tax, but I, being one of the many people who've moved to Australia, many people move here and they don't actually realise the issues that come with them from a UK perspective and in relation to the long arm of inheritance tax and how it can affect someone moving here. It also affects Australians as well, so that may be, for example, someone who's decided to buy a property in the UK, whether for holiday purpose or investment purposes, or it may also affect people who've actually married or met UK spouses, and that's an issue there. So just the first point to make, because this is a very complex area, this isn't intended to be advice. So just a disclaimer here, so if you are affected by these issues, it's important that you only take my comments as general comments and you seek advice on that, maybe from a UK perspective and also from an Australian perspective, where David, for example, will be able to assist with the Australian tax aspects. So looking firstly at what to know about UK inheritance tax. So the problem with UK inheritance tax is it has a very low threshold. So you're liable to inheritance tax in the UK at 40%, so it's a big hit above your available nil rate band, and that's only £325,000 for an individual. You do have the concept of a transferable nil rate band if you're married, so that can be up to 650,000, and there's also the prospect they're bringing in at the moment of up to an additional 200,000 each to cover your main residence. But you can see it is a low threshold there. And the other issue with inheritance tax is it's determined by the concept of domicile. So this is very different to residence. So you can become resident in a different country, so Australia, quite easily. But being domiciled here is a more difficult concept. You can, for example, remain resident in Australia for 40 years. And if you ultimately intend to return to the UK and you don't consider Australia to be your ultimate home, you can be still what's called domiciled in the UK. And domicile will look at all the links you have to Australia and the UK. And you can, if you're originally from the UK, you have what's called a domicile of origin in the UK. You can then acquire what's called a domicile of choice in Australia. You'd acquire that if you intend to reside here permanently or indefinitely. And you need to look at all the links between that. And the difference, though, is very important. So if you're still domiciled in the UK, then you're liable to inheritance tax on your worldwide estate, including anything in Australia. But if you're domiciled in New South Wales, the big difference is it only covers, inheritance tax will only hit you for what you own in the UK. So there's a big differentiation there. There's also a concept called deemed domicile. So if you move to Australia, even if you intend to stay here permanently on moving here, then you're deemed domicile for inheritance tax purposes for 3 years after you lose your UK domicile of origin. So even though you may intend to reside here, if you die within those 3 years, you're subject to inheritance tax on your worldwide estate. Now, there is an exemption between spouses. So you need to be married here. It doesn't cover de facto relationships. If you're married to someone of the same domicile, so two UK individuals, for example, then you can transfer your estate on one death to the surviving spouse free of inheritance tax. Inheritance tax will only kick in on the death of the survivor. However, if you, for example, have moved here and you've met an Australian spouse and got married, that doesn't apply, and you're only able to transfer inheritance tax-free up to £325,000. So this is important because you can accidentally call there, but it may be that you have an Australian spouse and you have decided to stay here permanently, and therefore you may have got a domicile of choice here, and that would mean that would be exempt between spouses. Just another point to add here in terms of trusts. So if you set up a trust in Australia, which we often see because it's a good way of planning for tax and also asset protection, but you're actually still domiciled in the UK, then anything you transfer into that trust above your £325,000 nil rate band will be liable to inheritance tax at 20%, and also then there's 10-year anniversary and also exit charges of up to 6%. So it's important that you look at your domicile position before you actually set up a trust if you're from the UK. Moving on to the next slide, I can't see any questions yet. So just to cover some of the changes that the UK were due to bring into place on 6th of April this year, before I look at ways of having to deal with inheritance tax. So the UK proposed they were going to make three important changes to inheritance tax that can affect individuals here. These were due to come into effect from the 6th of April, so it would look like they were already in place. But the UK Finance Act that was due to be passed was actually very slim, and that's because of the UK election, and didn't actually include these measures. However, looking at discussions in the UK from the tax authorities there, it appears that once the election has taken place, this will then be legislated, and because everyone has been given notice of it, it's likely to be retrospective, so it will still come into place on the 6th of April. So really four important points to take away here in terms of the changes. So the one being one of the main ones is if you're an individual from the UK, sorry, someone who's not from the UK, and you set up an Australian trust, and that holds UK residential property. So this is a really common way of protecting that property for inheritance tax in the past. So the changes say that that will no longer be possible to shelter it from inheritance tax by holding it through an Australian trust, for example. What that means is that once that change takes effect, then that trust will be liable to 10-year anniversary and exit charges of up to 6%. And the trustee will have tax reporting and compliance obligation with the UK tax authorities. Linked to that is the fact that loans for UK residential property will no longer have a special status for inheritance tax. So you used to be able to basically borrow money on that property, and it was only the equity that was liable to inheritance tax. But they brought in strict rules regarding that, particularly where the money is borrowed from offshore. One that may affect individuals here who have lived here for a long time, but then they decide to move back to the UK, is that they'll no longer be able to take advantage of a subsequently acquired foreign domicile of choice when they're resident in the UK. So if, for example, you'd set up an Australian trust and then you decided to move back to the UK, then that trust, which was exempt from inheritance tax potentially, will be subject to the 10-year anniversary and exit charges I was talking about. But the big issue is the trust will be deemed, if it's settled or interested, which most Australian trusts will be for UK purposes because of the extent of control you have in them, then all of the income and gains will be taxed on the settlor, which is actually the person who puts the majority of the money in and not just the person who puts a nominal sum in. And finally, the other change, which probably won't affect many people here because it really affects Australians who are resident in the UK, is they're bringing down the number of years of which you'll be deemed domicile for all taxes, inheritance tax, capital gains tax, inheritance tax from a UK perspective, from the current 17 out of 20 tax years of residence to 15 out of 20 tax years. So all of these changes are significant, and in particular they're going to affect Australian trusts in terms of their compliance and tax reporting obligations. Moving on to the next slide. So this discusses what can you actually do about inheritance tax, because there are some things you can do to try and mitigate it and to try and make sure that you're not potentially subject to it, or if you are, then taking steps to reduce your liability. So the main one here, if you're living here and have acquired what we discussed before, the domicile of choice in Australia, is we'd recommend preparing a statutory declaration of domicile. This is a formal legal document which sets out all the links you have to the UK and all the links to Australia, and why you intend Australia is your permanent or indefinite home. It's not fully binding on the UK tax authorities, but if something were to happen to you, and this were to be your domicile status were to be challenged, then by having this document, it's a good form of evidence against that. You need to wait at least 3 years on moving here to do it, but we certainly recommend it in situations where people have moved here and decide to make Australia home. If you are subject to UK IHT, then there are a number of things you can do. So if you're actually domiciled here, you can try and have as little assets in the UK as possible, because then, first of all, it's only what you're liable to in the UK that's subject to inheritance tax if you're if you're domiciled in Australia. If you are subject to UK inheritance tax, though, what you can look at doing are a number of lifetime giving steps. The first one is you can make £3,000 worth of gifts every year to any number of individuals, and there's also another 250 on top of that. If you've got lots of income around, then you can actually make gifts out of income, which won't be subject to inheritance tax, but that would very much depend on your own circumstances. It mustn't be seen as affecting your own lifestyle. The big one, though, is potentially exempt transfers. So what these are is if you are looking at a big inheritance tax bill, you can make absolute gifts, for example, to your children, and if you survive for 7 years, then these gifts aren't subject to inheritance tax. And if you die within that 7 years, there's a tapering regime whereby there'll be a different rate of inheritance tax applying. So this is what lots of wealthy people in the UK do, is actually give away their wealth whilst they're living to avoid inheritance tax. Another option to resolve inheritance tax is to look at making property in the UK subject to debt. But again, as I mentioned before, that's more complex than it was, so that would need to be looked at carefully. If you're looking at trying to reduce your inheritance tax bill as well, what you can do is make gifts to UK charities, because that will reduce your bill because they're not subject to inheritance tax. And finally, another thing to look at, which are very complex but need to be looked at carefully, is whether if you've got a business or a farm, for example, if they would qualify for what's called business property relief or agricultural property relief. And there are strict requirements around qualifying for that, but that is an option if you are subject to that. So I can't see any questions regarding that at the moment, but I'll just move on to some other issues for you to consider. So that primarily focused on inheritance tax, which is a very complex area. But often we'll find that people move here, and it's not just a case of inheritance tax that needs to be looked at. There's the need for, first of all, planning. So what happens if you were to die? So it's very important for all people to make sure they have a valid and effective will. This is complicated if you're from the UK and have retained assets here, or if you're from Australia and have bought assets in the UK. So the basic position is this: if you, for example, bought a property, UK law will determine what happens to that property on your death. So you can either have an Australian will, which covers your worldwide estate, including us in the UK, or what we usually recommend, where someone owns property in the UK, is having a will in both jurisdictions, because it makes the administration of your estate faster and more straightforward. Because if you have just an Australian will, when you die, you need to get what's called a grant of probate, and that will then need to be resealed in the UK. So it's a longer, more complicated process. Where if you have a will in both countries, then that simplifies it. Also, because of the inheritance tax issues we spoke about before, it's often preferable to have an Australian will separately because it can be more flexible in terms of what you do in your Australian will, which you can't actually do in the UK will because of the inheritance tax issues. So frequently what we'll advise clients to do is to have what are called testamentary trusts in your will. And what these are just basically tax effective and asset protective effective trusts in your will, which you can't usually have in your UK will, but you can have in Australian wills. And they have significant advantages for the beneficiaries of your estate where it's appropriate. The other thing to consider as part of it is what happens if you get ill or you have an accident, and that means you're no longer capable of managing your affairs. So in New South Wales, we have what's called an enduring power of attorney document, which deals with that. So you would appoint certain people, that may be your spouse, and then say, for example, adult children, if your spouse can't act, as your attorney to make financial decisions and if you lose your capacity. So this covers things like making investments, selling property, dealing with day-to-day finance issues. But that's limited to New South Wales. It can potentially cover Australia as well, but the same would apply in relation to the UK. So you need to have a document there called what's called a lasting power of attorney, and that's similar to the Australian enduring power of attorney. The other thing to consider for property investors in particular is UK capital gains tax. So until 2015, April 2015, if you lived in Australia and were a resident here, you weren't liable to UK capital gains tax if you sold a UK residential property. From April 2015, though, this has changed. So any gains from then, even though you're not UK resident, and this only applies to residential property, not other assets, will be liable to UK capital gains tax. So if you sell a property in the UK, you're going to have to do an apportionment there in terms of working out what's liable to capital gains tax there. The next thing to look at is UK income tax and stamp duty. So as there's been talk of here in terms of property investors, the government is looking to try and curb that. And the UK government is somewhat ahead in terms of what they've done there. So they make big changes to try and make it less attractive for property investors, because it was seen as something that was putting first-time buyers, for example, as a disadvantage. So what they did there was lessen what you can actually deduct in terms of mortgage interest, and that applies to higher rate UK taxpayers. So you may not be able to deduct all of your mortgage interest. There's a complex formula for doing that. If you're looking at buying another property in the UK, then they've changed the rules there to impose an additional rate of stamp duty at 3% on people who already own properties. So that can affect property investors in particular. And the final point to make is just in relation to Australian tax and disclosure. So if you've moved here, it's very important that you are up to date with your Australian tax reporting obligations here in respect of UK property. You can't just think, oh, I'm paying the tax in the UK, I don't have to pay anything in Australia. That needs to be dealt with, and David's team here are very well experienced in dealing with that and be able to help you with that. It may also be that, say, for example, you've inherited a property in the UK from a deceased relative, so it's important that that's disclosed to the tax authorities here, and it may be you need to get up to date with your tax filing obligations here, and David's team will be able to assist you with the disclosure here as well. So that brings to an end to this presentation. I'll just quickly cover if you do have any issues with this, the process for dealing with this before moving to questions as well that anyone may have. So I won't go through all the next slides. This just outlines the process that Hall&Wilcox have in terms of preparing for your estate planning, including UK inheritance tax. So this just covers how we work with that, some common issues for you to consider, one of which is UK inheritance tax there, and our process there for dealing with that. And we work with your advisors here at WSC to ensure that everything works effectively, and if appropriate, UK advice is obtained in relation to, say, for example, having a UK will. So that brings an end to the webinar. I'll pass you over to David now.
Yeah, thanks very much, James. And